So thanks everyone for giving us your time here at the Summerville Seba Beach Land Use Bylaw Project online open house. We're gonna go through a series of slides here just to discuss what has been done with this project to date, some of the engagement that was undertaken earlier in 2024, the process that our office, Municipal Planning Services Administration and Council, kind of went through to prepare the draft land use bylaw as is written today and on the website. Um, Give you some basic information about what a land use bylaw is, what it seeks to achieve, and also what some of the key proposed changes, deletions, additions are to the draft land use bylaw based on feedback that we got from the community and guidance from council, and just the next steps in this process. We understand that not everyone has had the chance to even look at the land use bylaw, let alone fully understand what's in the draft. So hoping that this can be a bit of an introduction to what's in it, help you guide you in your reading of it. It's a long document. And if you have further questions, there will be contact information about how to reach us. So the way we have this set up is if you have questions during the open house, rather than have everyone kind of unmute and kind of ask questions throughout verbally. If you can, we recommend that you direct your questions to Shauna or Marina at MPS. They're co-hosts in this meeting, colleagues of mine, and they can gather up those questions. And if it's a simple one, they might be able to answer for you directly in the chat, or they can kind of raise it to me and answer it as we go along, or we can collect them at the very end, depending on the number of folks in this meeting. If you prefer to ask your question verbally, we can kind of open that up at the very end here. But um, I guess I would recommend that you start by reaching out to Sean and Marina in the chat, and see if they can help you and if they need to raise it with me as we go along here. So as I was mentioning, we'll talk a little bit about what a land use bylaw is, about what's in the current land use bylaw of the Summer Village. The Summer Village has a current land use bylaw. It's been in the works, or I guess been on the books since 2008. And there was a land use bylaw before that as well. Um, we'll talk about a bit about what some of the objectives for this project are, what the process has been to date, what some of the key changes have been to the draft land use bylaw, and how we kind of came about that based on engagements and council direction, and what next steps are for this particular project in terms of collecting feedback from residents, uh, going over it with council and considering it for the adoption process and future public hearing. So a land use bylaw is perhaps the longest, biggest, and one of the most important bylaws that any municipality is going to adopt. It is something that all municipalities in Alberta have to adopt, whether you're the city of Edmonton, city of Calgary, or you're, the smallest summer village in Alberta. All municipalities, whether you're a village, a town, county, you have a land use bylaw, and this has been in play for several years now. Some municipalities have land use bylaws that are even older than the Summer Village's current land use bylaw from 2008. Um, they are reviewed, updated, and amended from time to time, depending on if new land use and development features emerge, uh, different trends, or if just priorities in the community change. Um, it is the set of rules that establishes the different processes for applying for development permits, for doing subdivision in your community, how notification of those development permits and subdivision is done, if enforcement needs to be undertaken because of non-compliance with the development permit, or you are in contravention of the land use bylaws, rules, and regulations, how that enforcement is done, how appeals are made, how amendments are made to the land use bylaw. It establishes all those different processes. But perhaps even more importantly, it is the set of rules and regulations that deal with how specific and general land use activities in your community are undertaken. So whether you're looking to build a home, an accessory building, a fence, it provides you with the measurements and the rules and regulations for how all that is done, whether you need to apply for a development permit, how tall a development can be, how much of your lot can be covered by development, um, and really just about anything that you would need to consider. The land use bylaw should be under its best intentions, providing you with those answers so that it can be done safely and efficiently. Land use bylaw divides your municipality into different districts. Some jurisdictions around the world or North America call them zones or a zoning bylaw. When you hear zoning, it's the same thing as a land use bylaw. And in Alberta, we refer to zones as land use districts. So within each district, whether we're talking about a residential district or a park and recreation district or a commercial district, each of those areas are identified with permitted and discretionary uses that identify what is allowed or may be allowed within each district. So permitted uses are things that are permitted, and if you apply for it and you satisfy all the other requirements in the land use bylaw, you should be good to go. And discretionary uses are the ones that the development authority and your development officer really need to kind of think about whether this is an appropriate use for this particular site, and whether it would potentially cause land use conflict issues with adjacent properties, or um, uh, other neighboring land uses. So just to summarize all of that, the land use bylaw is kind of the toolkit that the municipality like the Somerville Giuseppe Beach uses to regulate land use and development in your community. Your current land use bylaw is several years old now. It is by far not the oldest land use bylaw that we've been kind of working with in terms of updating and kind of modernizing. But given that it was written in 2008, a lot of new and updated provincial regulations and policies have changed, specifically in terms of how appeals are made and to whom, how development permits are processed and issued and notified, and different things too in terms of setbacks from environmental features. Different agency and department names are inconsistent, and it doesn't nullify your current land use bylaw as it sits today, but it just makes things more complicated for not only your development officer, but for community members to read the bylaw and not fully understand that some parts of it are kind of null and void and severed um, from the main document because of superseding provincial legislation or regulations that need to be followed in addition to everything else in your land use bylaw. A few years back, I think around 2020, you adopted a new municipal development plan, which guides future land use and development in your community and sets those priorities for what you want to see done in your community in the future. And in that municipal development plan, there is a lot of policy and guidance in terms of protecting not only the lake but the shorelands around the lake, to enhance and where possible improve water quality in your community. So where those policies directed kind of land use and development matters to consider things like watershed management best practices. We in doing this review included draft regulations in the land use bylaw that kind of mirror what's in your municipal development plan. And you also have an intermunicipal development plan with Parkland County, which kind of guides how you will, you know, what types of uses may be allowed in your community in the future. So both of those documents were not contemplated or were not even created when your current land use bylaw was created. So it's things that need to be considered when we're considering an update to your land use bylaw. So some of the main objectives in this project, as guided by council, have been to ensure that those bits of legislation and regulations at the provincial level are made consistent. Consistency with your municipal development plan and your intermunicipal development plan. So everything that guides what can happen in your community at a provincial and municipal level need to be reflected in your land use bylaw. We wanted to ensure that your maps reflect your current property boundary information. So any lot configurations that have changed or um, shoreline changes that have happened are reflected in the mapping of the document. One of the main objectives in land use bylaws recently have been to reduce red tape where possible by identifying as, as much as possible what application requirements are going to be or that may be required when you apply for a development permit so that an approach in older land use bylaws like your current one has been to say that application requirements will be basically anything that the development authority may need to look at. So in order to provide developers and prospective builders and community members at large with a better understanding of what application requirements might be, we wanted to spell those out and provide as much clarity in terms of the language of the document and just spell out what may be asked for at time of development or if subdivision were contemplated, what those application requirements may be, so that it was out on the table and it was something that can be understood. We want to address modern land use and development pressures. What folks were looking to build and develop in 2008 and before that aren't necessarily everything that folks are able to do or looking to do today in summer villages. And as demographics change and as housing demands change, we always just need to be cognizant as to whether or not the land use bylaw is keeping up with what those pressures are and whether they are either allowing the types of things you want to allow or purposefully excluding and contemplating the types of uses you don't want to see in your community. Because similar to the red tape point, if it's unclear, it just creates more confusion and process delay overall. And based on feedback from residents as part of a survey that we did earlier, implementing watershed management best practices where appropriate, and as identified in municipal development plan seem to have been priorities for your community. So where possible, we try to include regulations that do its best to ensure that development is done in a way that isn't going to negatively affect the local environment. So to date, we kind of began this project back in, I believe, late 2023. We launched, or sorry, we had meetings with council and administration in 2023. We launched a newsletter notification in January 2024 that included a survey for community members that provided questions about land use and development matters generally and a little bit more specifically in terms of some targeted topics that council and administration kind of came up with us to get your thoughts on what you felt were priorities for your land use bylaw. And I got to say, Seba Beach, I think, has set the record so far in the last little while in terms of Summer Village survey completions. We had 130 surveys returned to us, which is amazing to see. It provides us with some pretty good baseline information in terms of uh, kind of understandings, what your community has felt about some of these topics. And where possible, we've identified in this presentation how the feedback that we got from that reflects um, uh, how it reflects in the updated land use bylaw. From those surveys that we got, a what we heard report that was prepared by our office and shared with council and administration. So that summarized all the feedback from that survey, whether it was kind of graphed answers to questions or if it was just written feedback. We included that in a report to council so that they could see all the feedback that we received. And from that, council gave us some guidance on making some changes to the land use bylaw. We put together that in the summer of 2024. And then following that, we got to work preparing a draft land use bylaw. So we prepared, I think, the first draft land use bylaw in July of last year. And up until January, just recently, we made a few kind of draft one, two, and three based on council's review of the draft, so that it was further tweaked and revised to make sure that it hit the things that council felt were important for the community. Um, the so that's the process to date. We are gonna go through what some of the summary of proposed changes are to the land use bylaw. So how it differentiates from your current land use bylaw, we'll kind of go over that. And also give you a bit of an understanding as to what each section in the land use bylaw means and how it's important to you as a community. Um, I just I think we just received a question about addressing how older homes get implemented in some of these get implemented through a land use bylaw. We will cover uh, kind of developments that have already occurred. So this land use bylaw is not something that we'll be looking to, once it's adopted, kind of go house to house and try and figure out, which one is not in compliance with those regulations. If you were um, if you have a development permit for something today, it'll still carry forward into the future. If you were, built before there was a land use bylaw, there are processes that, sorry, um, uh, there's a consideration for that. So it's not a matter of going and trying to move houses around so that they fit within the measurements. There will be uh, a section that we'll talk about very quickly about those types of uses. So in terms of some of these proposed changes, um, what we kind of took as an approach was to include some information at the beginning of the document that provides a bit more information to the reader, whether it is a community member, member of council, or a prospective developer in your community, with an understanding of what's in the land use bylaw and if it has changed at all. So we added a page in here that would list future amendments to the document. So if this was adopted tomorrow, and a month later you decided that you wanted to include a provision in here for, allowing casinos in the summer village of Seba Beach, and you amended the land use bylaw accordingly to allow that, this list would update it to reflect what that bylaw number is, what land it affected, and what the proposed change was. Um, we also included a guide to using the land use bylaw. And by doing that, it's something that is not approved as part of the land use bylaw. It is something, it's almost like a bit of a preface, like if you were reading a nonfiction book to give you an understanding of what's in the land use bylaw, kind of an executive summary of sorts. A land use bylaw is a very complicated document. Even folks like myself who deal with them on a daily basis, it's not something that you can quickly get someone an answer to because there are often a lot of kind of different sections in it that you need to consider when when thinking about a particular type of development, whether it requires a development permit in the first place, what the maximum height would be, but if there are any notwithstanding clauses that may apply to it, and if it can be done within a particular district in the first place. So this guide just helps you to kind of slow down, understand that you need to kind of have a wider look at the document. And if you do want to proceed with an application or an amendment or have a question about an enforcement matter, it is a good idea to reach out to administration or your development officer to help kind of guide you through the land use bylaw, um, and be able to answer those questions for you. So that's something that's not approved as part of the bylaw. It's something that could change as new information is added to the land use bylaw through amendments, or if administration notices that there's particular confusion around a certain topic. But it's just included in there to help you kind of understand how to read the document. The beginning in section 1 is kind of the first bit of the regulations in the document. The administration section is something that's kind of carried forward from your current one. And it includes a lot of administrative topics, kind of housekeeping topics in the land use bylaw. It identifies what the title of the document is, when the land use bylaw was, when it commenced, upon third reading, what that date is, that it repeals the previous land use bylaw. So in this case, once this land use bylaw, or if it is adopted, it will be repealing your current land use bylaw. What the purpose of the uh, land use bylaw is, what it applies to. And just to clarify, the land use bylaw only applies to land within the summer village. It doesn't apply to anything in the county. It doesn't apply to the bed and shore of Wabamun Lake. It just applies to lands within your municipality. Uh, the conformity is a new section in here, and it just indicates that um, all land use and development matters, land use and development needs to be in conformity with the land use bylaw going forward. Compliance, just because you are compliant with the land use bylaw doesn't mean that you can disregard provincial and federal laws, any agreements or caveats or um, uh, agreements that you might have otherwise between utility providers or right-of-way owners or uh, other entities that you need to still be in compliance with those. Severability is a section that was updated briefly, but it indicates that if a section in here is made null and void because of changes to provincial rules and regulations, that the entire land use bylaw isn't thrown out, just that that one particular regulation gets essentially severed from the rest of the document, and the rest of it just carries forward without it. And fees and forms, it just indicates that all fees kind of mentioned or referred to in the land use bylaw will be as per your fees and charges bylaw, and that forms can be created by the different authorities that implement the land use bylaw to collect information related to applications and that sort of thing. So fees and forms aren't part of the land use bylaw, but they're something that get created to help implement it. Section 2 covers what the authorities are. These are the folks that are responsible for enforcing, implementing, and making decisions about the land use bylaw. And we just wanted to identify what their roles and responsibilities are. Council has, the biggest job in all of this. They have to adopt a land use bylaw, but they also have to consider amendments to a land use bylaw, um, and and what that process looks like. So we wanted to identify what that is, and if any land in your community is designated in a direct control district under the Municipal Government Act, the development authority in that situation is council, not the development officer as appointed by council. So in that situation, on those particular lands in a direct control district where special considerations are often needed in order to address unique or special circumstances, council becomes the development authority for that. So we just wanted to identify that as well. There are sections in here just identifying what the roles and responsibilities are of the development authority as appointed by council, and as the development officer, kind of implementing uh, development permit applications, receiving them, maintaining a copy of the land use bylaw on behalf of the Summer Village, um, and just enforcing regulations within it. There wasn't a spot in your current land use bylaw for the subdivision authority, and not like the Summer Village is going to be getting a ton of subdivision applications, but we wanted to identify that the subdivision authority is as appointed by council, and will be performing the duties as identified in your land use bylaw under the subdivision regulations. And the subdivision and development appeal board section, that was updated because there are situations now where development and subdivision appeals may not go to the local subdivision and development appeal board, but may go to the Land and Property Rights Tribunal, which is a quasi-judicial kind of arm of the provincial government that deals with land use and development matters where there is a provincial interest at stake in land use and development matters. So we just wanted to update that in terms of identifying that the local SDAB will perform such duties as identified in the land use bylaw when they are the authority in that situation. One of the longest sections in this land use bylaw is Section 3 interpretation, and that's where you find the list of definitions, terms that are defined in the land use bylaw. The current land use bylaw has approximately 87 definitions in it. We bumped this up considerably to 219 approximately. And it's not a matter of us getting paid per definition or anything like that. Just going back to the topic of clarity and providing as much sunshine as possible, we wanted to provide as many definitions as possible in your land use bylaw so that there is common language between administration, council, and potential developers in terms of what um, what particular types of development are and what information is that may be asked for as part of the development. Just thinking about conversations that I've had recently, the difference between a deck and a patio, the difference between a modular dwelling and a manufactured home, what a garage suite is versus a garage, whether an attached garage is the same as a garage. Things like that you kind of have to think about a little bit. If one person can have a differing opinion as to what that means as opposed to someone else, and that definition isn't in the land use bylaw, it can just create a lot of confusion, kind of running in circles, and it just kind of slows down the process considerably. And we wanted to kind of reflect what we've gotten back from different um, legal professionals who have indicated that if you want to identify things in your land use bylaw and not include them as permitted or discretionary uses, you really need to define them, identify them, and just create that common language in it. So we put several more terms in here that are used in your land use bylaw. Things like adjacent. So if we're talking about an adjacent property, what that means, what a dwelling is, as opposed to something that you might, whether a recreational vehicle on a driveway counts as a dwelling, or if it is just a place that you're sleeping in, what a geotechnical report is, or what a historic resource are, and very specific things like deck, a minor home occupation, garage suite, and leaving land in its natural state. So Section 3 interpretation, it kind of goes on for several pages. It is something that I wouldn't read and operate heavy machinery afterwards. It'll put me to sleep. But it just wants to ensure that there's understanding when we use these terms, what they mean. And where these terms are used in legislation or otherwise, we recognize that will kind of supersede it in some situations, but where it's used in the land use bylaw, we wanted to just be able to clarify the differences. Section 4 amendments covers information about how the land use bylaw can be changed. A land use bylaw is, as much as it is a kind of authoritative document, it is not written in stone, so to speak. It can be changed. It's not an easy process. It's not something that can happen tomorrow. It requires a public hearing. It requires three readings by council, not all of which can happen at the same meeting. And it often requires engagement with the community to provide input on changes to a land use bylaw. So we clarified and expanded what the process is. So we identified who may apply, and that could be council, that could be administration, or it could be community members coming forward saying that they, want to see that casino in the Summer Village of Seba Beach, just using a kind of comical example here. But it could be just about anyone who would apply. But just applying alone or asking for it is not enough. We need to be able to identify what those application requirements are going to be. So if you are looking to redistrict or rezone your land from one district to another, whether it is from a residential district to a commercial district, we would need to have some supporting information about who the landowners are, what you're looking to do, what you're looking to build, and additional information that may be required to assess the suitability of the amendment. Um, it outlines what the process is for receiving it, for council considering it, and for Summer Village administration to review and prepare reports for council's consideration. And what the holding of the public hearing and the reading process would be. And all of that is made consistent now with the requirements that are in the Municipal Government Act. So as best as possible, we try to reflect what that um, process is in the Municipal Government Act, but just expand it a little bit more to provide some clarity in terms of what those particular steps are. Section 5 in the land use bylaw, and within that section, there are different subsections that are fairly important that I just wanted to make sure that we cover specifically rather than as a section, section 5 as a kind of uniform section. But section 5 covers development permits. So if you are looking to do development in the Summer Village, whether that is building a new home or digging a very deep hole, those are all different types of development, and you need to kind of check this section to understand whether a permit is needed, and if one is, what the application requirements are going to be, and what the process is for going through that development permit application. So this section describes what that process is. It's been significantly updated to reflect what the changes have been to provincial legislation in terms of notification, timelines for deeming an application complete or incomplete, but also to reflect what some modern application requirements are. And going from 2008 till now, it is much, much easier to provide aerial photography, orthophotography, and just generally find information about a site that wasn't quite as prevalent or easy in 2008. It's easier to draw drawings, and the ability to kind of prepare information as part of your application that assists the development authority in making an educated assessment of the application. Um, we wanted to reflect those application requirements to understand what the development authority is going to be looking for as part of the application. Section 5.1 has been updated in a very minor way to just identify that a system of development permits is the process in which development is achieved in an orderly manner, and that it's the responsibility of a development proponent to determine whether they need a development permit, and to obey the rules and regulations of the land use bylaw. Um, sorry, just one second here. Section 5.2 is a pretty important section as well. It lists the types of developments in your community that do not require a development permit. It's something that's in your land use bylaw today. And it is something that we always have a close eye on when we're reviewing a land use bylaw to ensure that the types of land uses and developments that you don't want to have to request um, residents in your community to have to go down to the Summer Village office and apply for a development permit for, that you want to make sure that those types of uses are listed here. Because if a type of use is not listed here, it does require a development permit to undertake. So usually this is a more of a lengthy list. We do like to add additional things on here to ensure that we're not asking for development permits for things that you wouldn't necessarily need a development permit for. But if it's not listed, it's something that you will have to apply for. So some of the things that we've added to this list, and just to clarify, are if you're doing a fence below the maximum height requirements, and doing any fence maintenance, that doesn't require a development permit. Building retaining walls under a certain height, 1.2 meters, and that doesn't affect offsite drainage. Those types of things do not require a development permit. Any landscaping or general yard maintenance, planting flowers, that sort of thing. There's always confusion when we talk about development being any kind of disturbance of a land. That is the definition of development. But just doing some landscaping, minor landscaping, that doesn't affect adjacent properties, that type of activity doesn't require a permit either. The same for removing hazards or dead trees and vegetation, normal yard maintenance, that sort of thing. So I just advise everyone to have a close look at this list. Um, there are some carryovers in here from your current land use bylaw dealing with small accessory buildings, things of public utilities and um, uh, efforts, or I guess developments done by the municipality or levels of government, and other minor things. So just please have a close look at this, and if anything seems off or shouldn't be on the list or is missing from it, reach out to us. There'll be contact information at the end of the presentation here. Section 5.3 covers non-conforming buildings and uses. And non-conforming buildings and uses are types of developments that today wouldn't conform with the land use bylaw, but were developed at a time when they probably were. So if we're talking about a 60, 70-year-old home that was put down in the summer village prior to there being a land use bylaw, um, it covers how that type of use can continue into the future. Um, it's something that's covered in the Municipal Government Act. Um, and we just updated the section to, or sorry, we included some information in here to just reflect what's in the Municipal Government Act. But basically, if you are under a development permit from the current land use bylaw, and proposed changes to this draft land use bylaw would not make you consistent with it, that that development permits is still applicable. You would still be able to continue. There are, some limitations on redevelopment of those particular developments or uses. But it's not a matter of, you need to, come into conformity within a certain number of days or anything like that. You'll still be able to continue. The only caveat on that is that if you were, disregarding the land use bylaw of the day or not applying for a development permit when you should have, those enforcement matters might still, be applicable. But this is not an attempt to kind of get rid of old cabins or old homes that predate any land use bylaw, let alone the current or the proposed new one. So there are additional things that just kind of need to be considered, but it kind of builds in a bit of a grandfathering clause, so to speak. Section 5.4 covers those development permit application requirements, and this section's been updated, I think, somewhat considerably, just to identify what some of those application requirements are going to be. uh, and what will and what may be required. So in some situations, all development permit application requirements are going, or all development permits are going to have to provide certain information. So whether we're talking about post-construction site and building elevations or height of proposed buildings, location of footings, that sort of thing, um, providing a scaled site plan, providing the application fee, an ortho photo of the property, or I guess an aerial photo, which you can basically put together with a lot of free mapping sites out there. Um, those are the types of uses that have been updated, or sorry, those are the types of application requirements that have been updated in the draft land use bylaw to identify what will be required of all applications. In some situations, a real property report may be required when we're talking about new buildings or additions, or if the development authority thinks there might be an issue with where the proposed building is to be sited on the lot, and several other studies, reports, and um, kind of information provided by qualified professionals that may be required in some situations, depending on what types of uses and developments are being proposed, so that the development authority is able to properly assess whether it is appropriate and suitable for the location in which it's being proposed. So going back to what we were talking about in terms of providing clarity and reducing red tape, we wanted to just kind of be upfront about in some situations there may need to be a geotechnical report or a wetland assessment if wetlands are in the vicinity, or lock rating and drainage plan. Those types of things that whether it's your surveyor or your engineers are probably going to have to be considering anyway. That's information that the development authority is going to um, be in a position to ask for um, as certain applications are made. So not necessarily it's in every situation type of scenario, but um, it is something that the development authority could ask for. And it's the same thing today. It's not spelled out clearly in your current land use bylaw what some of those things are. So if you are looking to develop and you see what some of those things are in that very short list, you might be surprised when you know when a geotechnical report is asked for as part of the development permit application. But by spelling it out and putting it out there clearly, it will hopefully prepare some folks for what potentially may be asked for. We included a section in here dealing with the demolition or removal of buildings. Um, if a Under the development permits, or sorry, developments not requiring a permit section, anything that didn't require a permit to go up doesn't require a permit to come down. But things like larger accessory buildings and homes that did require a development permit to be constructed in the first place, it kind of makes sense that a development permit be required to ensure that it is taken down in a manner that ensures that it is done safely, that hazardous materials are collected and disposed of properly, and that impacts on adjacent properties, the lake, and municipal roads and other infrastructure are not kind of damaged or impacted negatively as part of a building removal or demolition. So there's just some additional information about what those application requirements would be in terms of preparing hazard material checklists and identifying, how the buildings are either to be come down, to be taken down or to be removed. Section 5.6 and 5.7 deal with updates to the Municipal Government Act in terms of notifying when a development permit application is either deemed complete or incomplete. It in Up until a few years ago, there wasn't that requirement in the Municipal Government Act, and in changing it it puts the onus on the development authority to deem an application complete or incomplete within a certain number of days. And we need to just reflect that in the land use bylaw. And same for development permit notices. When they are issued and sent out, we just updated this to be consistent with what's in the Municipal Government Act in terms of who gets notified and the manner in which it's notified. Section 5.8 deals with conditions and development agreements. And this just identifies what conditions may be applied to a development permit, and when development agreements may be utilized um, as an agreement between the Summer Village and the developer to ensure that infrastructure and other utilities are um, provided to the lot according to municipal standards. And we updated it to identify when a bond or irrevocable credit may be required in some situations. So those situations may be when the proposed development may pose a potential impact on local roads or infrastructure, or to ensure that landscaping is completed as per the requirements of the development permit. So the Summer Village can today, and we just spelled it out in here that they may be looking for just assurances to protect their infrastructure and to ensure that landscaping is done properly and not left in a mess situation that could impact adjacent properties or the lake if not completed. Section 5.9 deals with the cancellation of development permits and just identifies when a development permit may be deemed invalid. Um, so if you have a development permit for a house today and you apply for a new development permit that deals with that house, that supersedes the previous development permit. And it also identifies when it may be canceled and for what reason. So if it was issued in error, or if incorrect information was provided, or if new information was provided that kind of nullified or made or indicated that the information provided previously was wrong, a development permit can be canceled. Section 510 deals with variances, and variances are the provisions that allow the development authority to look beyond the strict, rigid nature of the land use bylaw and consider special situations that where those regulations may need to be relaxed to allow reasonable types of development to occur in specific sites or areas that have unique development considerations or unique lot shapes, or just to fit in, um, to allow something that would reasonably make sense to happen in an area, fit in, even if it doesn't comply with every little regulation in the land use bylaw. That's something that's provided for in the Municipal Government Act today, but we wanted to spell that out in the land use bylaw so that it's a known thing that can be applied for. It's not something that should be sought in every situation. A variance is kind of should be used, in my opinion, should be used fairly rarely to deal with those special circumstances, but it is something that can be considered. Uh, there are no caps in the Municipal Government Act in terms of how much of a variance can be applied for or granted. So in putting together the draft land use bylaw, we, with council, identified that when we're talking about variances dealing with things like building height and parcel coverage, a variance can be applied for and can be considered to a maximum of 10% of the applicable regulation. So if special circumstances required you to be thinking about building a little bit higher, you can't go, you know, um, you know, 5 stories higher. It would have to be 10% of that height requirement. And same thing for the parcel or lot coverage provisions. It is just capped at 10%. Some summer villages have gone the route of not allowing any variances whatsoever for building heights, parcel coverage, and other matters. So it's just something to consider and think about when you're reviewing the land use bylaw, if that's something that you're supportive of as well. 511 deals with the issuance of compliance certificates. So when one is applied for by a resident, it just identifies what information may be required um, to issue a compliance certificate and what the process is for the development authority. And that deals with section 5, which is your development permit development section. So if you're looking to build and recontour or do any type of earth moving or building moving in your community, section 5 is the one you want to have a close look at in terms of ensuring that those rules that you're are fitting what you're looking to do in your community in the future. Section 6 deals with matters of subdivision. And again, there's not a lot of subdivision that could happen in the summer village in the future. But we dealing with things like boundary adjustments and um, re-subdividing of existing lots. If that were ever to be done, it would have to go through a subdivision process, and we just wanted to include what those steps are, so that it is clearly spelled out in the land use bylaw. There is a requirement in the Municipal Government Act that all land use bylaws have to identify um, uh, when or the deeming of an application complete or incomplete, whether or not you're getting subdivision or not. It's a requirement in the Municipal Government Act that that be in there. So rather than just throwing it in randomly, we just included a brief section about subdivision process. Section 7, dealing with appeals, just describes how a development or subdivision appeal may be made and to which body. So if you have, um, if you apply for a development permit and it was refused and you want to appeal it, this section just identifies how that appeal process is made. And it clarifies that in some situations it may go to your local subdivision and development appeal board, but it may also go to the Land and Property Rights Tribunal. And we just wanted to be clear on that, that there could be situations where that is where your appeal may end up. Um, there in your current land use bylaw, it kind of lumps together subdivision and development appeals, and there are now different or slightly different sec processes for development and subdivision appeals. So we just pulled those apart and created them into their own subsection. So there is a subsection now dealing with development appeals and one dealing with subdivision appeals, and what those processes, howbeit very similar, are how they're kind of followed and lead to an appeal process. And we just made it consistent with the Municipal Government Act requirements for holding a hearing, which are fairly well spelled out in the Municipal Government Act. So we just cited what those applicable sections are in the Municipal Government Act. Dealing with enforcement. So if you are not, so if you built a house on a lot and you didn't get a development permit, you could reasonably be expecting enforcement to occur uh, related to that type of development activity. But if you also were doing things that are in contravention of your approved development permit, or just not complying with the rules and regulations in the land use bylaw, this section just identifies what enforcement may occur, how it is done, by who, and what the end result may be. And it could be receiving warning letters, it could be receiving stop orders, violation tags and tickets, whether it's issued by a designated officer or a peace officer. But dealing with matters of enforcement, this section is specific to the land use bylaw. It is not everything that the summer village may want to enforce or what residents may want to see be enforced. It is limited exclusively to the land use bylaw, and it is very much consistent with the powers provided to the municipality by the province through the Municipal Government Act. All of the provisions in here in terms of issuing stop orders and offenses and fines and violation tags and tickets are all options available to the municipality today. We just wanted to provide what that information is incrementally so that you could understand what your rights are if you want to initiate an enforcement action or if one is initiated upon you due to a letter you get about a development on your property not conforming with the land use bylaw or conforming with your development permit. The next two kind of big sections in here deal with kind of it's kind of the stake in on the menu here. It is it deals with the regulations that cover the general and specific land uses that may be developed in your community. That these are the regulations that deal with these things specifically. So Section 9 deals with general land use regulations. So these are considerations that would apply just about in every possible situation, whether we are talking about relocating buildings or doing landscaping, building fences on properties, or um, dealing with signs, parking, loading, that sort of thing. Um, it's the supplemental regulations on these topics. Your current land use bylaw covers about 13 of these different topics, probably a bit more, but they're kind of scattered throughout and not highlighted in their own subsections. We pulled all of these out and put them into Section 9 General Land Use Regulations so that they would all have their own heading. They would be easy to find in the table of contents, and you would be able to kind of pull up what those regulations are and understand them a little bit better. And we included them alphabetically here as well. A lot of land use bylaws just kind of had them in random order. So hopefully this provides a bit of an easier way of finding what those sections are. The ones shown in red on the screen are the ones that are proposed new sections in the land use bylaw. And the ones that are highlighted in yellow are ones that I have some additional slides and information on so that we can talk a little bit more about what's in the land use bylaw. So one of them is dealing with environmental protection. And I included just on the bottom of the slide here from that survey that was issued in 2024. One of the questions that we asked in the survey was what types of regulations would you like to see added in the land use bylaw? And one of the more popular responses to it was regulations to support water conservation best practices, or sorry, watershed conservation best practices. And there's not a lot of that in your current land use bylaw today. So we included some proposed new regulations in here in this new section dealing with things like discouraging the removal of vegetation, excluding noxious weeds, because I know that's something that the summer village undertakes to control the noxious weed population in your summer village. In areas within that 6 meters of the front property line on lakefront lots, prohibiting the permanent disturbance of watercourses, wetlands, and water bodies, requiring that shoreline modification be discouraged, but if required, that it be done through a development permit, and identifying that it may also require provincial approvals as well. Minimizing the use of hard landscaping elements and ensuring that shoreline modification include or incorporate revegetation efforts, and prohibiting the addition of sand and other materials to the bed and shore of the lake, or adjacent lands adjacent to the bed and shore of the lake, to help protect the water quality of the lake and enhance watershed conservation efforts in the summer village. Section 910 deals with fire separation and emergency preparedness. And I think for just about all of us, this is something that is always on the back of our mind, particularly in the summertime. There are not a ton of, well, I'll even go as far as to say there aren't any regulations in your current land use bylaw that deal with um, siting and developing on a property to ensure that or to reduce the spread of wildfire. And a lot of land use bylaws, particularly in more rural and remote areas, are um, updating them based on the recommendations in the Fire Smart Manual, the provincial adopted one, but as well as the federal one, uh, that provides those recommendations on how to limit and reduce the spread of wildfire. So things like having minimum on-site building separation requirements so that your accessory building is not right up against your home in the future. If you're looking to site one in the future, so that if one catches fire, the other doesn't necessarily catch fire and then continue on down the line. The land use bylaw encourages the use of fire retardant materials so that it has each building has a higher fire rating in the future as they're redeveloped or replaced in the future. Placing non-combustible landscaping materials uh, adjacent to um, buildings. So whether we're talking about woody shrubs and things that might catch fire, that they be planted away from homes and accessory buildings and materials that are not going to be easily combustible are the ones that you are putting near developments in the future, and storing combustible materials further away from dwellings. We added into just to be consistent with other summer villages and their approach to fire pits. Just some basic regulations in terms of where they can be sited on a property and screening materials and that sort of thing to ensure that things like embers and fences aren't going to be a problem um, uh, as fire pits are used in your community. Grading, stripping, and drainage is something that isn't specifically addressed in your land use bylaw. And going back to that survey, one of the responses to the question is what are key environmental considerations around the lake, protecting the water quality of the lake. Um, when we are doing grading, stripping, and drainage on a lot, these are things that, if not done properly or done in such a way that um, is not, managed properly, these are things that can impact the quality of the lake. So in your current land use bylaw, there's not a whole lot in here on requiring development permits for grading, stripping, and drainage. Um, so what we included in here at council's request was that when you're doing stripping, grading, or altering drainage on a lot that could impact adjacent lots or the lake, that those types of land developments require a development permit. That lots be graded so that any runoff flows heading towards the lake are as clean as possible. Same for any runoff that heads towards the street or other municipal infrastructure. That a lot grading drainage plan may be required for developments that increase runoff onto adjacent, that could have the potential to increase runoff onto adjacent lands or to alter runoff into the lake. And if a lot grading drainage plan is required, when it is required, it should include things like identifying what the pre and post development lot elevations and grades are of the lot, identifying what the designed elevation, what the surface gradients and the swale locations will be, identifying how runoff will be controlled on site, and any other information required by the development authority to ensure that the lot grading and drainage plan will not result in a negatively impacted lake or adjacent properties. Tree removal is something that is not included in the current land use bylaw. And chatting with council, we included regulations in here dealing with um, tree removal to prevent situations where lots are being would be completely cleared of all trees or significant tree stands. And it's not a situation where tree removal is not permitted in the summer village. but that it be done under a development permit process to ensure that if trees are being removed, that the reason for doing so is identified, how uh, replacement trees will be provided, discouraging the removal of trees adjacent to water bodies and water courses, and just providing I, regulations in there too that identify that when we're talking about hazardous trees or dangerous trees or diseased and dying trees, that those ones, you can go ahead and remove those if they're going to create a problem or create a safety situation. But if we're talking about removing more mature trees and tree stands, that there just be some thought and planning done to just replenish the tree stand of the overall tree canopy of the summer village. This is something that was identified in your municipal development plan, raised when we did that a few years back. Maintaining the tree canopy of the summer village was something that the community felt was important. So by adding this section in here, it'll just hopefully prevent situations where trees are, just being disappeared overnight without a development permit and without a plan for replanting and replacing. So that was section 9, dealing with the very general land use regulations that deal with all properties in the summer village, whether we're talking about the different residential districts or commercial districts. Um, those regulations kind of apply in all scenarios. Section 10 deals with the specific land use regulations. Um, and in your land use bylaw, there's really only 4 topics that really kind of we were able to pull out and identify as specific land use regulations. We up this to include uh, um, about 11 different topics here, 3 or 4 of which are kind of on the same topic, dealing with suites. And the ones that again that are identified in yellow, we just have some additional slides and information to present here. But we invite you to review and look at all of them here so that we know that they're if you have thoughts and ideas about them, to reach out to us. Manufactured home dwellings, in your current land use bylaw, they're not allowed. Um, and in the current land use bylaw, only single detached dwellings and modularly constructed homes are allowed. So modularly constructed homes would be the RTM type of homes that, when placed on a lot and assembled, you can't necessarily tell the difference between that and a stick-built home. Um, that's just a construction method. So single detached dwellings are really the only type of dwelling allowed on a lot in the summer village. So manufactured homes, or mobile homes, as you know, they were often called, are not allowed today. In the proposed land use bylaw, we carried that forward under council's guidance, and indicated that no new manufactured homes shall be allowed in the summer village. So if there is 1 or 2 or more in there today, it's not written in such a way as that they need to go right away. Um, but we have just identified that no new ones will be allowed in the summer village. And we revised the definitions in section 3 interpretation to just clarify that difference between modular constructed single attached dwellings and things like manufactured homes. So there isn't confusion about what's a modular dwelling versus a manufactured home. Park model trailers, that's something that's fairly common in lakeside communities today. It's not something that is specifically addressed in the current land use bylaw, which creates matters of confusion and misunderstanding. Um, in the proposed land use bylaw, we carried forward the regulation that primary dwellings have to be single detached dwellings, and that park model trailers can't be used as a primary dwelling. So a park model trailer is not a single detached dwelling, but they can be used as a garden suite. And we have additional slides just a little bit later on about dealing with things like suites. Um, but they can be used if if all other provisions in the land use bylaw are properly covered and addressed in terms of lot coverage and setbacks, we could be in a situation where a park model trailer on a lot could be used as a garden suite to provide additional kind of living space on the lot. Recreational vehicles, this is a topic that was kind of raised in the survey back in 2024. We had a few questions in here about it, and I think there was some pretty good clarity on some of the answers in terms of how many recreational vehicles should be allowed on a developed lot. The majority of answers indicated that one be the maximum. There were a few responses indicating that two or three or more should be allowed or could be allowed and under you know, different scenarios. Some folks indicated that zero should be allowed, but there were a fair bit that indicated that residents should be allowed to have one on a lot. And in asking the question, how many do you have on a lot? Out of the responses that we received, the vast majority indicated that zero are on a lot. Um, the next highest response rate was for one. And then as we go higher than one, the numbers dwindle considerably. So looking at this, it would indicate that the vast majority of residents have either zero or one recreational vehicle on a lot. And in terms of how many should be, one seems to be the predominant response here. So in your current land use bylaw, one RV may be placed on a developed lot. So that's consistent with that. But the regulations that are as they're written today just indicate that it can only be occupied maximum of 72 hours within a 30-day period unless authorized otherwise by the development authority. And I know there's been a little bit of confusion on that in terms of whether that's being followed or adhered to properly or in every situation. So in working with council in the proposed land use bylaw, we've expanded this section, I think, to be consistent with the overall approach of allowing one on a lot. But we wanted to clarify under what situations one can be allowed on a lot and when situations may allow for an additional recreational vehicle, what needs to be satisfied to allow that. So allowing in the proposed land use bylaw, it allows a maximum of one recreational vehicle on a developed lot without a development permit. So everyone is allowed to have one on their lot under this proposed land use bylaw regulation. One additional RV may be placed on a lot for a maximum of 4 days, 4 consecutive days to a maximum of 21 days a year with a development permit. So if you are looking to potentially have a second one on your lot a couple of times over the course of the summer, that would need to be under a development permit. And it wouldn't have to be for a specific recreational vehicle, but it would just be identifying where a additional recreational vehicle may be located on your lot to ensure that it is meeting all lot coverage and setback and safety requirements so that it is not creating a safety concern or covering too much of the lot with additional non-permeable surfacing. We expanded it also to include that recreational vehicles can't be placed in the front yard of a lakefront lot, so closer to the water, and that the recreational vehicle and towing vehicle must be placed entirely on the lot and not parked in part or entirely out on the street or in the ditch or within the road right away or on adjacent properties. That if you're going to be placing an RV on a lot, it has to be entirely within the lot. So our approach on this was to kind of follow the guidance of the survey feedback. Council kind of looked at this and agreed with us in terms of the situation seemed to indicate that one is the appropriate answer here, and that if there is going to be an additional one, it has to be applied for and ensure that it is done in such a way that is cited on the property properly. Section 10.7 to 10.10 deals with different guest house suites. Your current land use bylaw deals with guest houses, um, which could be things like a garage suite, a garden suite, so a standalone accessory building in the backyard or in your yard, side yard, whatever, and secondary suites as well. So an addition um, onto your dwelling or in your basement or in your attic, a situation where a suite is developed. So we pulled each of those out and created them into their own subsection, and just kind of followed the general guidance of the current land use bylaw in terms of how many may be allowed, and in terms of how big, and expanded a bit in terms of the regulations to just ensure that they would be secondary and subordinate to the dwelling on the property. So in your current land use bylaw, guest houses are allowed. Um, they require a development permit. It doesn't differentiate or provide different regulations for garage suites or garden suites or secondary suites, um, in a way that is very clear. It does provide for a maximum of one on a lot, and it indicates that it can be in the rear yard only, so not in the lakefront lots on lakefront lots. Sorry, lakefront yard on lakefront lots. And in looking at the 2024 survey, we asked what types of regulations you'd like to see added into land use bylaw or clarified in the land use bylaw. And the biggest answer out of all of this was the ability to develop guest houses and garage suites on lots. So knowing that this is an important thing, and that community members were looking to do this, we included, we expanded on those different topics, and just clarified what the sorry, not the application requirements, but what the regulations would be for them. So a development permit is required. So if you're looking to build a guest house suite, whether it is a garage suite, a garden suite, or a secondary suite, a development permit is required, same as it is today. A maximum of one may be developed on a lot, same as it is today. So if you have a garage suite today, you can't also have a garden suite or a secondary suite. You gotta kind of gotta pick and choose which one you want. Um, they need to be developed on a lot with a dwelling already on there. So it can't be a vacant lot. So you can't be putting up a garage suite on a lot and calling that the dwelling. You need to have a dwelling on the lot in the first place before we can be considering a garage, or sorry, a suite situation. Same as it is today, maybe located in the rear yard only. Um, Clarified and expanded, I think, to include that cooking and bathroom facilities may be allowed within suites. I think the current land use bylaw was a bit silent on that, and from council's direction, we included that cooking and bathroom facilities may be developed within suites. We didn't make any changes to the maximum height. So if we're talking about a standalone garden suite, it can be a maximum height of 4.3 meters. And a garage suite situation where a suite is built above a garage, the maximum height is still 9 meters. And just clarified that it has to be secondary and subordinate to the primary dwelling on the lot. So it can't be a situation where, um, a condemned and decrepit uh, old cabin on a lot is just forgotten about, and a suite, a massive garage suite is applied for a new accessory building, and that become the new primary residence on the lot. It has to be, the overflow, the additional accommodation room for the primary residents and their guests. This is an accessory building, so it should be secondary and subordinate to it in terms of living space and use on the lot. We also included in here tourist homes, which is again going back to 2008, not something that was widely regulated or thought about in many communities, but is definitely something that a lot of summer villages are amending and updating their land use bylaws to cover. Um, the proposed regulations that council kind of guided us to put together in the draft land use bylaw for your review. It kind of covers tourist homes, so all short-term rental situations, whether we're talking about Airbnb, VRBO, or anything else that has a commercial method of payment and um, booking and reservation system. Those are that's what would constitute a tourist home. If we're talking about a rental situation where you are renting month to month in the community, that's not something that we're looking to regulate, um, or rent for 6 months at a time. I believe in the definition for a tourist home, it covers situations that are 30 days or less. So if you are looking to develop a tourist home, either within your dwelling or on your lot, it shall require a development permit, and the development authority can consider issuing this for a temporary period only. So it wouldn't necessarily be a permanent development permit. It could be issued for a period, say 12 months, and then reconsidered and reapplied for in the future. Maximum of one tourist home on a lot. So if you have a garage suite and a dwelling on your lot, you can rent out the dwelling as a tourist home under one booking and have the garage suite as a second one and have, a bachelor party in one and a bridal party in another. Um, it one on a lot only. So whether it covers just the home or the home and a suite, we're looking at one booking at a time. Requirements. There are requirements in here to display that a copy of the development permit. So anyone looking to rent a tourist home in the summer village will clearly see that a development permit has been issued, what the maximum occupancy is, and a home and safety and evacuation floor plan also be provided, so that anyone coming into the community uh, under this model will understand if their booking is in excess of what the development permit allows for, and be able to understand what the safety and evacuation measures would be in the event of an emergency. The maximum occupancy shall be the number of bedrooms in the dwelling or in the tourist home, times two to a maximum of eight. So larger parties beyond eight would not be allowed, with the caveat that children under 12 don't count towards maximum occupancy. Because it's I'm not going to go about regulating number of children within a tourist home, but we can certainly kind of put a cap on the maximum number of adults and larger persons in a tourist home just to ensure that it's not a situation where large groups bigger than those numbers are going to be coming into your community and potentially causing disturbance. Um, a tourist home cannot be developed or operated within a recreational vehicle on a lot, a tented structure, or any accessory building without cooking and bathing facilities. So if you have a garden suite that only has a bed and a television in there for guests to stay in overnight and they come in and use your bathroom facilities, that can't be rented out separately. Um, it, it we're doing our best here to identify what Alberta Health Services has been identifying as um, dwelling and living situations that are subpar and substandard. And whenever we circulate to agencies like Alberta Health, to get their feedback on land use bylaws, they always have a close look at tourist homes and suites, because they want to just make sure that folks aren't living in unsafe conditions, whether it is just for one night or for longer periods. We're getting to the end of the presentation here, but sections 11 to 19 cover the land use districts in your land use bylaw. And by and large, we didn't make any major changes to the land use districts. The residential districts have remained as they are. There's been some minor tweaks in terms of the permitted and discretionary uses just to reflect what the new and revised definitions are as identified in Section 3 interpretation. And we made some minor edits in terms of formatting and wording just to improve clarity and consistency, just to be able to more clearly pop what the requirements are within each land use district. Um, I can just quickly show um, the land use district map on the left is your current land use district map. It is a black and white map created back in 2008 or maybe even just before. And it kind of points to areas that are within different districts. Right now in the Summer Village, there's two residential districts, the R1A Residential Large Lot District, which covers most of the Summer Village. There's the R1B Residential Small and Shallow Lot District, which covers a lot of the lots going further north up the road in the Summer Village that are lots that are smaller and more narrow in their configuration. There's a C1 commercial district that deals with general commercial uses, a commercial recreation district, an urban services district, and a parks and recreation district. So all lands within your summer village are within any of those districts, and I think they generally all kind of make sense in terms of which is located in which. The current land use bylaw map is a bit hard to read in terms of what each label is pointing towards. The boundaries identified on the map are a bit unclear in terms of what is a property boundary and what is a road versus what is a land use district boundary. So we color coded it and just included some uh, just made it a bit more pop in terms of uh, being able to more clearly identify which district different properties are located within. But in terms of changing anything on this map, it is as is today. So hopefully it is just a little bit more clear to read. I think there are one or two lots dealing with commercial and urban services that we just need administration and council's eye on just to make sure that we're covered properly in terms of uh, whether they are properly designated and, or sorry, districted or zoned in the first place. But in terms of the residential lots, they are unchanged from your current land use bylaw. So the next steps for us, when this meeting's over and everyone goes back and kind of gets into their pajamas, my next step will be to hit end on the recording. We will upload it to YouTube that we have for municipal planning services for meetings like this. And we will share the link to the Summer Village so it can be posted on the website for anyone that either fell asleep from me droning on or had to leave for put kids to bed or go make dinner or just was unable to attend or carry on for the entire meeting. You'll be able to catch up and see what was missed. We will post that very shortly. We want to get your feedback. You can send it to myself, Brad McDonald, b.mcdonald@munplan.ab.ca. You can send it to the Summer Village and they'll direct it to me as well. Happy to have phone conversations as well. If you want to send me an email or kind of reach out to the Summer Village, they can provide you with contact information for me. So if you have questions or need clarification, reach out to us. I understand that for many of you, this is going to be your first time having a look at the land use bylaw, let alone understanding everything within it. So if nothing else, I hope this was a good guide to reading it. But we want to get questions and feedback and be able to compile community members' responses to the draft into a what we heard report for council to be able to provide them with some recommendations for changes and improvements to the draft before it goes to the adoption process. And when we get to the point where all that feedback has been reviewed and considered, and council has kind of directed us to clean up the draft and get it ready for adoption, the process is generally that there will be a first reading of the document where council formally considers it at a council meeting. They'll direct administration and municipal planning services to provide notification to the community and to agencies that the land use bylaw is being has been considered for first reading. We'll schedule a public hearing date. And the public hearing is a formal opportunity to kind of provide testimony before council on your thoughts about the land use bylaw. So if you have particular opinions about specific regulations or things that might be missing from it or changes that you would like to see, this is your opportunity to stand before council or to submit a letter to be read to council or to just provide that testimony to them so that they can consider it for um, as part of their part of the adoption process. If there is feedback provided at the public hearing, more than likely council will direct us to prepare a report based on the feedback that was received, and to give recommendations on potential changes to the land use bylaw. And then council can consider that report and direct us to make changes if necessary. And then once that is done, council can give consideration to the land use bylaw for second and third reading. So there's still more engagement and opportunities for feedback along the way here. But if we can get feedback, ideally by March 21st, so I think that gives us a little more than 3 weeks to kind of collect folks' thoughts on the draft. We'll prepare that into that report for council, and be able to put the draft land use bylaw into a situation where it kind of reflects as much as possible community feedback. So I will open it up if there's any questions here. If you do have questions, Marina and Shauna have been made co-hosts here, and I think they've been collecting comments or questions along the way. Happy to hear those. But if anyone wants to speak verbally here at the meeting, we kind of limited it in terms of uh, having chat questions for the time being, just to limit interruptions and just make sure that there weren't audio issues. But if anyone does want to have a say, send a comment to Shauna, myself, or Marina in the chat, or use the raise hand function and we can unmute you. But otherwise, throw a comment into the chat for them, and we can handle them along the way. If there aren't any, and that's entirely fine as well, it's not unusual either. We'll just look forward to receiving comments and questions in the future, and we'll prepare that into the What We Heard reports, and that'll be available for community members to read and review as well. So I am going to just take a speaking break here for the moment, but if anyone has any feedback, we'd be happy to hear it. Sean and Marina, have you received any questions?
You didn't get any.
Nope, neither did I.
I don't know if folks have, if you do want to send something in the chat, feel free. The one question that we did receive earlier on, the question was, at some point, can you address how those of us with older homes, 60, 70 years old, and perhaps even older, would be implemented in some of the bylaw sections? Given how some buildings are situated, we would either have to take down buildings or take down trees. Um, I think I think we covered that a bit, but just to clarify for anyone who might have joined late, uh, if a home or a development was done prior to the current land use bylaw or any land use bylaw and didn't require development permits at the time, we're not there are provisions in the Municipal Government Act that deal with non-conforming um, uh, land uses and developments, which allows them to continue going forward into the future. If they are, if unfortunately, they were burnt down and completely destroyed due to fire or some unfortunate accident, a new development permit would need to be applied for to replace them. But in terms of whether they can continue on into the future, that is something that is allowed for in the Municipal Government Act and carried forward in this land use bylaw. If there were to be expanded upon or redeveloped, there would need to be considerations for those variances and dealing with them as a non-conforming use. But we can work with individual older home uh, landowners as those situations arise. So if you are thinking about doing that in the future, we invite you to reach out to the Development Authority and administration before you kind of start putting together plans.
Hey Brad,
Yeah.
we just got a quick question. Is there a section regarding outdoor lighting and the use of security cameras in the new land use bylaw?
That is a good question. If you don't mind, I might just pop it open. I don't have every regulation memorized, unfortunately. Um, I think under the I'm just looking it up here. There is regulations. I'm sorry, I just want to go back. Um, there are regulations in here, and I can't remember if they're carried forward from the current land use bylaw or if they're proposed new ones. But under section 9.2 billion or building orientation and design, it does indicate that the development authority should have regard for things like sunlight and privacy. There aren't regulations, I don't think, dealing with outdoor lighting specifically, but that is something that land use bylaws often have, that outdoor lighting be oriented in such a way that it doesn't create offsite impacts for adjacent residences or things like that. That it be directed towards the ground and covered and screened in such a way that it isn't a nuisance or an annoyance. So if that's something you would like to see, we'll obviously collect that as part of the conversation just now, um, and include it in our report. But if you want to expand on it, feel free to reach out to us so we can provide you a little bit more information. But it privacy is in terms of how buildings are built, it is something that the development authority should be considering in terms of placement of windows and height of buildings and especially when we're talking about two buildings going up next to each other. Um, but in terms of surveillance, electronic surveillance equipment is a bit of a uh, complicated topic because it covers federal law in terms of um, and I apologize, I'm drawing a bit of a blank in terms of exactly what it's called, but in terms of recording and uh, rights to privacy. And I know that there's been some, it is hard to implement in a municipal land use bylaw, limiting surveillance equipment, especially when we're talking about doorbell cameras and security systems. I know some municipalities have worked with landowners to deal with particular situations as they arise, more mediated situations than anything else. But it kind of covers into federal law, which the municipal, which a land use bylaw is kind of superseded by. So we can, as part of the what we heard report, we'll just dig up a little bit of information about that. I know we did it for another land use bylaw very recently. But we can present that information to council and get their thoughts on it as well. Um, there was a question about a expanding on residential parking requirements. Um, just bear with me while I just kind of look. I'm just writing down a note as well. Um, there are, in terms of off-street parking, there are requirements in there for residential developments that all parking be done so that it is done entirely off street, that it has to be placed. I think it says here, not located within 1 meter of a parcel line common to the parcel in the public road. Shall be constructed in an adequate way so that access to and exit from each stall is safe and to the satisfaction of the development officer, and shall be hard surface to the satisfaction of the development officer or a gravel mixture approved by the development officer. So there are minimum parking standards on lots in the Summer Village. In terms of number of vehicles allowed on a lot, I don't think it covers that. And a lot of the parking and loading requirement regulations were carried forward from the current land use bylaw. It's not something that either council or I think a lot of folks in the survey indicated as something that was something that needed to change. But there are minimum number of parking space requirements. So if you were having a residential development on a lot, you have to be able to provide two um, parking spaces per dwelling, and if you're developing a guest house, you need a parking space as well for the guest house to prevent situations where folks are being forced to park out on the street and on the road and causing traffic and safety concerns and issues. So if you are doing those types of developments on a lot, you need to be thinking about where and how parking is to be provided on the lot. So there are minimum parking requirements. That's in section 918. I'd invite you to have a look at that and expand if we can expand the conversation if you want to reach out to us. Anything else, folks, that came in? Marina, Shauna, did any other questions come in?
I oh I just got one. Are recreational vehicle sizes defined? Is one 40-foot the same as two smaller ones?
Um, in the, I don't think that we limited, sorry, in the definition for a recreational vehicle, I do not believe it limits the size of one. And mainly because as soon as you start doing that, someone's going to have one that is slightly too big or whatever. So it doesn't differentiate one versus essentially if we're talking about one that is, let's just call it um 300 square feet. It doesn't differentiate that from two that are 150 square feet each and kind of create the same size. Um, the regulations would allow for one on a lot, regardless of size. And that's how it's currently written in the land use bylaw and how it's been carried forward into this. It's an interesting question to ask in terms of um, overall coverage. If the main concern in the community is, I guess, the coverage of the recreational vehicle on the lot, I could see that being a major concern. But I think just in terms of the number of persons or vehicles coming and going in the summer village, I think just by limiting it to the one might be the intent of the initial regulation from the 2008 land use bylaw. And as we kind of carry that general um, uh, approach forward into the land use bylaw, we just covered it as one recreational vehicle. There was a question about attendance, I guess here. I have been just kind of keep my eye on the number of participants. It looked like there's three from us from municipal planning services and a couple of counselors. I would think that we've had anywhere from 20 to 30 people kind of come and go here throughout the evening, knowing that no evening is particularly good to have a public meeting. Hopefully, by posting it on the Summer Village's website as a YouTube link, we'll be able to attract a few additional people. By doing so, we're able to also kind of gauge number of unique viewers of the video. So we'll be able to provide that statistic to council as well. But we'll have in the what we heard report approximate number of attendees tonight. And but just by the corner of my eye here, it looks like we probably had 20 to 30 different unique viewers. So if that's it, I'll just do a bit of a prolonged pause here. But again, I will just invite folks to reach out to us. We'll have that contact information on the Summer Villages website as well, so you don't have to worry about scribbling it down on a piece of paper and then losing it. It'll be available to you. We'll include our phone number as well, and you can reach out to us with additional questions as you kind of make your way through the land use bylaw. I apologize. It is a very boring document. I wish it could be more exciting and colorful and more excitingly worded. But a land use bylaw it's an important document, and it is a fairly legalese structured document that just provides those regulations that have to be written in such a way that there isn't confusion and a misunderstanding. That it just has to clearly spell out what the rules and regulations are on different topics. So hopefully we wrote them in such a way that is clearer than it is today in your current land use bylaw, but we just are limited in terms of how simple we can word things here. So Marina and Shauna, if there's nothing else, we'll call it an evening and say goodnight to everyone.
I don't have anything else.
Yeah, no further questions that I got either.
Great. Well, have a great night, everyone. We look forward to getting your feedback and having conversations with you in the future. So please have a great night and enjoy the good weather, and let us know how we can improve this draft for you. Thank you.